Mr. Hood goes on in this and says, North Carolinians tried, fought a war, lost the war, and then had to live under new state governments formed under terms set by the victors. Okay, now we're talking about the principle of conquest. Conquest is a legal principle which changes the title of the government. And so if North Carolina was conquered by the federal army, then the title transferred from the free people of North Carolina to the federal government. That's what I say actually happened, and that's what I say is unconstitutional and illegal, and we have a right to pursue that conquest as being illegal in the courts. As you can see, Mr. Hood says, you know, it's a waste of time to do this, that it's doomed for failure. I disagree with him totally. I think that this is a valid legal direction to go to get remedy for America today. In this country, we take the belief that all government of right comes from the consent of the governed, not dictated by a foreign power, which now, again, this is what John Hood, the founder of the John Locke Foundation, is arguing, is that the federal government has the authority to conquer people, in other words, subjugate them, force a new government on them, and then call them a free people. So you get your freedom through conquest and subjugation and a forced government, and then you have government of consent, and it's a bizarre concept. And then they have the concept of, well, that was 1868, but this was cured by a vote in 1971. Well, if you read the writings of Thomas Cooley, University of Michigan Law School professor, dean, who wrote many articles on constitutionality of issues, or what's the Constitution. He says that once you have a unconstitutional act, you can never cure it. No subsequent action can cure it. To cure the unconstitutional act, you got to deal with the unconstitutional act. You just can't say that something downline can cure that, because again, what did Reconstruction do? It annulled the body politic. It changed North Carolinians to where today a North Carolinian is not allowed to vote in North Carolina. Go look at your voter registration application. On a North Carolina voter registration application, you're required to be a United States citizen residing in North Carolina. The original people that could vote in North Carolina up to 1868 were the freemen of North Carolina, the citizens of North Carolina. Two different body politics. So the United States citizens residing in North Carolina having a vote to their form of government does not bind the freemen of North Carolina to that vote. And then we go to point 2. Mr. Hood says this: if the current state constitutional government is illegal, why attempt to get a state judge seated under the illegal system to rule on the matter? So in answering this question here, I don't have a driver's license because I don't recognize the state that's in operation today as being lawfully created. I don't believe that it can prove that it was lawfully created. I believe that Reconstruction was unconstitutional, that going into the war there was no constitutional authority for the federal government to wage war against states, to conquer them, to not allow secession. I believe there's issues on the constitutionality of that have never been settled. I have a right to go into court if they say I'm required to have a license, that I have a right to say I will not get your license unless you can prove your jurisdiction is lawfully created. The Constitution says you cannot have two jurisdictions within a state. I recognize the jurisdiction of the Constitution of December 18, 1776 as being lawful and binding, and has never been changed by the consent of the freemen of North Carolina. And it's still a valid government to rule over this soil. And that if they want to bring me in, I'm going to challenge jurisdiction. I'm going to come in under special appearance, challenge their jurisdiction, where I will get your license if you can prove you're a lawfully created state. They remain mute. There's a North Carolina Supreme Court case, State versus Batdorf, that says once jurisdiction is challenged, it must be proven on the record. And these people do not prove it. They just say, we have jurisdiction. I say, where's the evidence? I've got the surrender letter of the state of North Carolina. I've got the Military Order 120 issued by General Canby, where Colonel Williams is coming in and removing the government of North Carolina. So I'm not trying to get a judge to rule on it. What I'm trying to get a judge to is let law reign supreme in North Carolina rather than the will of men who want to maintain the overthrow of lawful government. if the operation of law reigns supreme in North Carolina, when I go into a court, or anyone goes into court, and challenges jurisdiction on the creation of the state because of Reconstruction, the state has an obligation to prove that its jurisdiction in law is lawful. They cannot do it. They refuse to do it. And it appears that Mr. Hood is in favor of this situation. When I was at that conference in Raleigh last week, I went up to Judge Orr, or Justice Orr, and Professor Orth, and I asked them if they knew of any books, any scholarly workings that proved the constitutionality of the Civil War and Reconstruction, and they said they couldn't think of any. Well, neither can I, and I think it's time to address this period of time.
John Ainsworth is currently the Chief Magistrate of the reestablished state of the North Carolina American Republic. John is also the founder of America's Remedy, an organization dedicated to bringing the untold history of America to the public eye. Visit ncrepublic.org and americasremedy.com for more information.